I am haunted by a ghost of a man I have never met. For nearly 2 years, I never even saw his face, or even a photograph that I could say for sure is him. I have never spoken to him directly on the phone. Really, I am haunted by a set of words on a page that I know is attached to a calm voice. I have heard his voice. All I know is that the words in this voice want my money, and they will not leave me alone until they get it. They never leave anyone alone. I'm not generally inclined to believe in the supernatural, but I really am haunted. Worrying about this situation has become part of my daily routine. I'm actually afraid that telling this story may be more trouble than it's worth. But it's an important story, and although it might first seem tangential and minor, I think that you, like me, will eventually come to realize that it's actually not. So allow me to introduce you to the world in which I live and in which you live. A world where there exists a rogue state that permits lawlessness on a grand scale, lawlessness that for years has gone largely unnoticed, and lawlessness that is, in a sense, contagious. A rogue state called Maryland. Were you expecting something different? I don't blame you. I've been to Maryland. It seemed like a pretty normal place. Just a couple of years ago, this was all new to me. But of course, Maryland is counting on that. Otherwise, it all just wouldn't work. From Think Press and PlainSite, this is Broken, a podcast about what we like to call the rule of law and how in the United States there isn't one. We'll talk about all aspects of the legal system through the lens of PlainSite, a legal and financial research platform where you can find information about things like lawsuits, lawyers, companies, and judges. On PlainSite, anyone can read anything the government produces for free, with no account. It really does put the world's complexity in plain sight. And that is why there are so many stories to tell, starting with this one. On the day this all began, I was blissfully unaware. I'm Aaron Greenspan. You could say I'm a tech entrepreneur turned information transparency activist. After a roller coaster of life events that took place starting when I was in college in 2003 and culminating in a settlement with Facebook and Mark Zuckerberg in 2009, which I then used to start a payment system, I created PlainSite in 2011 with two friends from Stanford. Initially, it was a project to better understand why nothing had happened in the wake of the financial crisis. I had other reasons as well. More than a decade later, both have since gone off to do other things, but I've stuck with it. I live in California, so there are a lot of things that happen every day in Maryland, in all kinds of places, that I have no knowledge about or interest in. But on this particular day, July 20th, 2022, I had a significant interest in knowing what was happening in Maryland. That was the day that a ghost sued my company. This ethereal being filled out a form, printed out some words on a page, walked into the courthouse in Upper Marlboro, a place I'd never heard of, and paid a fee. A clerk took his papers and deemed them acceptable. The clerk typed some things into a computer and put the papers into a folder. The world kept spinning, and I happily went about my life. I had no idea. Now, if you've been listening closely, you may want to stop me here. I just told you that I run this legal information service, right? How could I have no idea that someone had just sued my company? It's true, PlainSite does keep track of what's going on in the justice system and on Wall Street, a bit like Westlaw, Bloomberg, or LexisNexis, with a bent toward investigative journalism. But it's not perfect. None of these services are. Achieving totally comprehensive coverage of every court in the country is extremely difficult. And compared to the giants of the tech industry, PlainSite barely registers, except on one dimension. Having devoted much of the past few years to researching Tesla and Elon Musk's other companies, PlainSite has been something of a heavy hitter when it comes to unearthing news about certain billionaires. But otherwise, most people have never heard of it. There are exceptions, of course. Sometimes people searching for their own names on Google will come across a lawsuit they didn't even know about, and ask us to suppress it from search engines or remove it entirely. Evaluating these privacy requests is a tricky business that requires a lot of time and careful consideration. Court records in the United States are in the public domain unless they are under seal, which means that anyone can do whatever they want with them. Open access to court records is what keeps the press free, because if you think about it, a huge proportion of the daily news cycle is based on what happens every day in courts. Running PlainSite alongside other activists, nonprofit organizations, and journalists, I've been on the front lines of the battle to keep that access open and open it further. Publishing court records makes you a magnet for interesting situations, because the debate over whether information should be widely known or secret implicates pretty much every important issue there is in business and government. There are roughly 30,000 privacy requests in the PlainSite database, of which 8,000 are marked as spam or duplicates. Of the legitimate ones, some are totally straightforward. A witness in a case against the drug cartel wants to keep their name off the internet. No problem. Or while it's still pending, a judge has issued an order officially sealing the entirety of a case, or even a portion of it. Done. Or a whistleblower at a company doesn't want their next employer to find their case on search engines. We abbreviate the whistleblower's name. Others are more of a gray area. What do you do when someone isn't lying when they say that they're part of California's Safe at Home program for victims of abuse, but they've also filed for bankruptcy 4 times, filed a bunch of lawsuits in various courts, and they've been sanctioned? Or what do you do when a judge seals a case 20 years after it was decided, and every law library in the country already has a copy of the decision sitting on a bookshelf, which means it's also plastered all over the internet? Is it even possible to honor such a sealing order? Or what happens when someone is sued for credit card debt, but it's a lot of credit card debt, nearly $50,000? Should that be public information forever? What do you do when a notorious Turkish crime family starts making threats if you don't comply with their wishes and take down their case, even while it remains on other websites, and it seems kind of important that people understand what they've done? For one thing, you write up an ironclad privacy policy so everyone understands how the First Amendment works and how your website fits into it. My favorites are the colorful requests, the ones that maybe express understandable frustration with the justice system in ways that I don't think anyone could have predicted. The requester who said, in response to an automated message from PlainSite, and I quote, "This is simple and you need to control yourself and not let a Haitian witch with diabetes do witchcraft to put words in your mouth and tell you what to email me." End quote. Of PlainSite's 30,000 privacy requests to date, only 3 have come from people, all of them criminals of one sort or another, who have decided to get into an actual legal battle with Think, the company that runs it. Criminal 1 was the convicted murderer who fought back after I obtained a restraining order against him, which could be the subject of its own season on a podcast, and may very well be one day. Criminal 2 was a man in Ohio who sued the IRS, arguing that he didn't have to pay taxes. He lost. Then he appealed that loss and lost again. He argued that the information about his case being public was hurting his chances of getting a job, so he sued every court site on the internet and Google for good measure. It took about 1.5 years and a few $1,000s in attorney's fees before it was dismissed since he appealed, but there was never any real question about his lawsuit going anywhere, especially since he also filed 6 other lawsuits against a woman he was stalking, his apartment complex, and prospective employers who had decided not to hire him, among other parties. At that point, he didn't have any criminal record, but then he violated the restraining order that the woman he was stalking took out against him, and lo and behold, he was also looking at criminal proceedings. And then there was this case, Criminal 3. It wasn't until August 8th, 2022, that I had some inkling that something might be amiss. On that day, I received an email from the mail forwarding service my company has used for years, ever since Criminal 1, the convicted murderer, began stalking me for refusing to remove his criminal case records from PlainSite. The email said in cheery bold letters, quote, "Your scanning request has been processed!" Which is what it always says when something comes in the mail, even though it's not like I'm making a separate request each time. I double-clicked on the attachment and was greeted with an image of an envelope from Mahassan El Amin, whose title, Clerk of the Circuit Court, was written below her name. It was postmarked from zip code 20772 and addressed to Think Computer Corporation, with my name underneath after the word serve. The page that followed is what was in the envelope, a yellow-orange piece of paper that said, quote, "Notice. You are hereby notified that upon a demand for a jury trial, this case was transferred to this court and entered on 20 July 2022. Notice to defendant. If you are a defendant, counter-defendant, cross-defendant, or third-party defendant in this action, and you wish to contest the case against you, you must file in this court an answer or other response to the complaint, counterclaim, cross-claim, or third-party claim within 30 days after date of this notice, regardless of whether you filed a notice of intention to defend or other response in the district court. Date mailed, July 26, 2022, Mahasan El-Amin, Clerk of the Circuit Court. Notice mailed to, and then where you might have expected an address, such as my address, there was nothing. Having read legal documents for more than a decade by that point, I was pretty used to seeing notices and dealing with legal terminology. But I'd never seen a notice quite like this one. It wasn't on any kind of fancy letterhead. Everything was plain, typeset in Times New Roman, maybe size 11. It said it was from the Circuit Court for Prince George's County, another place I had never heard of. And presumably, Prince George's County was in Maryland because the address said that it was in Upper Marlboro, Maryland. Was there a Lower Marlboro, Maryland? Answer, yes. But there was no indication that the notice was even from the Maryland state courts. But there was a bigger problem. The notice was wrong. It said that I had 30 days, quote, after date of this notice to respond to the lawsuit, but that didn't really make any sense. How could any person even know what they were responding to in this situation? The court seemed to be assuming that I had been served with the papers, but I hadn't. Didn't someone check to see if there had been a proof of service filed first before sending out that language in this notice? Apparently not. There was a case ID on the notice, and below that, a district court case number. I wasn't entirely clear on what the difference was, and this is kind of my specialty. Through a joint program with the Stanford Computer Science Department and the law school, I was a Codex Fellow at Stanford from 2012 to 2013, when I quit the fellowship because it kind of seemed like the program wasn't taking legal transparency very seriously. I can talk your ear off about case numbers, court codes, location codes, serial numbers, judge identifiers, machine versus human readable, the way no two judges can seem to figure out how to write them down consistently. I wrote the code that allows PlainSite to parse case numbers in dozens of jurisdictions, and I was still confused as to what was going on here. I'd never seen a court refer to a case number as a, quote, case ID. Even more confusing for a California resident, the case ID started with the letters CAL. The notice said that this case was transferred, but I had no idea what case it was talking about. I hadn't received any paperwork about any case in Maryland. An average person could have been forgiven for thinking that this was just some kind of routine paperwork error or disregarding this weird orange notice as some kind of fake scam document. I get these all the time. An official-sounding directory claiming that I need to pay them $700 or $1,000 or $5,000 to be listed in a foreign registry of businesses, or companies masquerading as United States Patent and Trademark Office to siphon off cash from ignorant accounts payable clerks who don't want to be responsible for missing a deadline. Although there was a seal around the signature, this didn't look official enough to be real, but it also didn't have the telltale signs of fakery. It wasn't asking me for any money. It was just informing me in small, vague print that something had happened somewhere about something I was not aware of at all. It was bizarre. So I called the court. The only phone number on the notice, oddly, was for the hearing impaired. But I found the court's phone number easily enough and called up. If someone was suing me in Maryland, I at least needed to see a copy of the complaint. The court's hold music was cheery, maybe something you'd play in a music video where everyone is dancing in a big grid celebrating the efficient administration of justice, I guess. It didn't quite fit. I soon learned that seeing a copy of the complaint, something I do every day, dozens of times a day on PlainSite for cases nationwide, would not be possible. Prince George's County was one of the last counties in Maryland stuck on paper filing, with electronic filing slated to launch in October 2022, months away. If I wanted to see the lawsuit against my company, the clerks told me, I could come down to the courthouse. I informed them politely that I was 2,500 miles away. They had a solution for that too. I could send them a check for an undetermined amount of money based on the number of pages in the document I couldn't see, and then they would mail it to me. If you've never encountered one before, court clerks are the archetypal government bureaucrat. Even in the year of our Lord 2024, many consider the use of stamps, the kind that make a kerchunk noise when you press them down onto the page with ink, an integral part of their job. They know which forms you should use and which forms you definitely should not use. No matter how ridiculous the case before them seems, they dutifully type in the metadata, the parties, the document descriptions, the dates, the times. Even if someone has sued 400 famous people on the earth itself for violations involving the sun, the moon, and the stars, the clerks type in all 400 names. It's a noble job, but also one that might evoke some pity for the soul who is elected to deal with every single person who appears at the court's doorstep. That is, if they're reasonable. Many court clerks are not. Whether through a process of self-selection or because anyone would find themselves jaded after years of working behind that desk, it's not uncommon to come across clerks who seem to go out of their way to make life difficult. Part of this is because clerks have to be very cautious not to tip the scales of justice one way or another in favor of any particular party to a dispute. They also tend not to be lawyers and cannot give out legal advice as a result. So sometimes what seems like a reasonable question will be met with opaque and cryptic answers. But is explaining which form the court wants in a specific situation legal advice? You'd better hope that you're dealing with the right clerk and that they're having a good day. The clerks in Maryland were not having a good day when I called. They did not care that I was in California and that this bizarre notice had arrived in the mail. They did not care that I had a First Amendment right to access documents from what sure did seem like it was my own company's court case. I could walk into the courthouse, or I could choose not to, and pay for the documents to be mailed. Of course, this is not how things are supposed to work. Most courts do not hesitate to provide parties to a case with copies of documents in that case free of charge. It's a requirement. You have the right to know what's happening in your own legal proceeding. Whether that right is spelled out anywhere in writing is a different story. Most places would just chalk it up to the First Amendment. And most places these days have the documents online for free. I wasn't going to pay for documents in what was supposedly my own court case. So I decided to just wait. It took 3 weeks before my wait was over. On August 30th, 2022, some person at the court finally put a big envelope in the mail, slapped nearly $8 in postage on it, and on September 6th, it arrived at my mail forwarding service, which dutifully scanned it all in. Inside the envelope was a summons, an original complaint, and jury demand, the documents I had been asking the court for. Finally, I was able to gather some idea of what this was all about. I started reading the complaint. It was weird. The first paragraph, numbered paragraph 1, read, quote, "This court has jurisdiction over the matters alleged herein as the acts and omission given rise to this complaint occurred in Prince George's County," end quote. The sentence wasn't even grammatical. Acts and omission? Just one? Given rise, not giving rise? Whoever had written this wasn't leaving a great first impression. But the next paragraph, paragraph 2, was even weirder. Quote, "Plaintiff was a resident of Prince George's County in Fort Washington, Maryland," end quote. It didn't say at all times relevant or is a resident, just was. At some point in the past, maybe yesterday, maybe 100 years ago, maybe right now, it was anybody's guess. Reading a lawsuit isn't hard, but there are certain tricks you learn. A lawsuit starts with a complaint, which is the official name of the document that says what is being sued over. The summons comes with it, telling you that you're required to show up in court and respond to the complaint. The way in which you get the summons is called service of process. And depending on the court and the situation, it might be by mail, in person through a paid process server, by posting a notice in a newspaper, or even through the State Department if you're suing a foreign government. The most important part of the complaint is what's actually at the end. The claims, or sometimes counts. The word claim doesn't just mean what it means to the average person, as if you're suggesting something, because claims in lawsuits are what tie groups of allegations to specific causes of action, the laws that the plaintiff alleges are being violated. They could be anything from part of the United States Constitution to a federal statute to a local ordinance. So when you read a complaint, what you really want to know is, what are the claims here? And then you can start from the beginning to get a sense of the factual allegations that are supposed to support them. A well-drafted complaint doesn't have to be long. A well-drafted lawsuit is crystal clear. It leaves the reader, and the most important reader of a lawsuit will inevitably be a judge, with no ambiguity as to what happened, why it happened, who caused it to happen, and why that broke laws X, Y, and Z. Details are key. The question of how many details really need to go into a complaint is the subject of a surprisingly important controversy, and it's a fight that has played out over decades. To understand that debate, and really to understand this entire story, the most important thing you need to know is that there is nothing, and I mean nothing, more important when it comes to litigation than the rules. That's rules with a capital R. In federal court, when you're dealing with a civil lawsuit, the term rules refers to the federal rules of civil procedure. Each rule is numbered from 1 to 87, plus a few more that exist for weird cases involving maritime claims and Social Security actions, but that's really just the start. They're then broken into hierarchical sections and subsections, and this is just the federal rules of civil procedure. There's also the federal rules of evidence. In 1992, I was in 4th grade, and the United States Department of Agriculture had just come out with this new innovation which happened to be perfect for 4th grade public school curricula. By mandate of the USDA, the 4 food groups were out and the food pyramid was in. It had grains at the bottom, then your fruits and vegetables, then your meat and dairy, with sugar and fat at the top. Thinking back, I get what they were trying to do with it, arranging foods by roughly how much you should eat of each, but it's not exactly intuitive, and also it didn't really work. Americans are arguably less healthy than ever before. By 2005, the USDA had given up on the food pyramid and moved on to something called My Pyramid, which is just a jumble of food in a triangle, and then My Plate, which looks suspiciously like the 4 food groups. The pyramid idea stuck with me, however, and although I'm pretty sure that this isn't how it's taught in law schools, it's a helpful and actually sensible way to think about rules in litigation. At the bottom of the litigation pyramid, the wide base on which everything is premised, you have the United States Constitution and all of the amendments. Then, on the next level, you have federal laws or statutes. These are written down in the United States Code, abbreviated USC. On top of those, you have federal regulations, which are issued by executive branch agencies and which work in conjunction with specific federal statutes. Those are written down in the Code of Federal Regulations, abbreviated CFR. Then, on the next level, you have the Federal Rules of Civil Procedure, or as lawyers, for some insane reason, like to write it, Fed R Civ P. But we're not done. Each federal court has its own civil local rules, or because nothing really makes sense in the law, some courts actually insist on doing this backwards and call them the local civil rules. Obviously, the first way is right, but whatever. On the next level, you've got the court's general orders, which are just as binding as the local rules, but they tend to be more temporary, things like the orders that governed how the courts would work during the COVID-19 pandemic. And finally, at the apex of the pyramid, you've got your judge, who in all likelihood has his or her own standing order just for their own courtroom. So what I'm really telling you here is that when you go to a federal court, you're looking at having to keep track of 7 interrelated and sometimes conflicting layers of rules. And the sum total of all that, and the way that those rules get interpreted and enforced, is really what we mean when we talk about the rule of law. One of the specific federal rules of civil procedure, Rule 8, dictates the amount of detail that is required to be written down in a complaint in a lawsuit. And for decades, it just said that the plaintiff, the one suing, had to make a short and plain statement of the facts. Well, that changed. In 2007 and 2009, 2 Supreme Court decisions essentially eviscerated Rule 8 and completely changed the landscape for pleading standards. In Bell Atlantic Corporation versus Twombly, the Supreme Court changed the pleading standard from facts that make a claim possible to facts that make it plausible. Then, in Ashcroft versus Iqbal, the John Roberts Court made it clear that the new standard in Twombly didn't just apply to antitrust cases, it applied in all cases. Now, even though Rule 8 was fundamentally the same as it had always been, it applied to every case. The upshot of this change was that it would be much harder to be a plaintiff in a federal lawsuit going forward, because plaintiffs would have to be far more specific and detailed in their lawsuits. And defendants, who tend to be corporations, would have a much easier time getting cases thrown out. There was a big exception, however. All of these rules and Supreme Court precedents applied in federal court. State courts are a parallel universe. There is no Rule 8 of the Federal Rules of Civil Procedure. There is no Twombly. There is no Iqbal. There never was. Each state has its own constitution, its own laws, its own regulations, its own rules of civil procedure, basically its own litigation pyramid. And that makes state court a much different creature than federal court. If you ask most lawyers who have spent time handling litigation, they'll tell you something like federal court is where things are buttoned down and serious, like working in a New York bank in the 1950s. And state court is the Wild West. Maybe there's a sheriff in town, maybe not. Of course, not every state is the same. New Jersey's courts are different in a lot of ways than, say, West Virginia's. But the generalization holds. The complaint I was reading, filed in state court in Prince George's County, Maryland, was 7.5 pages long, dated June 8, 2022. But the summons was issued August 2nd, 2022, nearly 2 months later. It didn't make much sense to me at the time. Typically, the summons is generated by the court at roughly the same time the complaint is filed. But in this case, I'd eventually learned that in Maryland, the district court is more or less a small claims court, and I received the orange transfer notice. It was an indication that the case had been moved, at the plaintiff's request, to the circuit court, where the real cases were. Although the district court and the circuit court are treated as independent entities in Maryland, they actually occupy the same building in Prince George's County, making the distinction spelled out in some Maryland law more of an annoyance than anything else. The circuit court had issued its summons only after the case had been transferred. The district court had never even bothered to create one, which is why, when I first learned of this whole mess from the transfer notice, I'd never even seen the lawsuit. This was not a good system. I didn't have to read for long to find the claims in the complaint because there were no facts. Just that ungrammatical statement about jurisdiction, a section about the parties, which erroneously stated that my company was an LLC, and then straight to count 1, the first claim. It was for, quote, invasion of privacy by intrusion upon seclusion, which typically means that someone has physically invaded your private space, like your house, followed by count 2 for unjust enrichment. Count 3 was for violation of the Maryland Consumer Protection Act. Count 4 was for violation of the Maryland Personal Information Protection Act, an unfair and deceptive trade practice. Count 5 was for negligence, and count 6, the final claim, was for intentional infliction of emotional distress. The plaintiff wanted $25,000 in a jury trial for these alleged violations, plus punitive damages for what was deemed, quote, reprehensible and outrageous conduct. What had I done to allegedly violate all of these laws? According to the complaint, PlainSite had published the plaintiff's, quote, name, address, telephone number, email address, and other personal information. This was the information that the plaintiff had volunteered to the federal government when they filed whatever lawsuit PlainSite had published because they had filed without a lawyer. When you file pro se, you are the contact person for the case, and so you have to tell the court who you are and how to reach you. This is all public information. But this plaintiff was suing over it anyway. What kind of person would file something so obviously frivolous? Who was this person, I wondered? I had dealt with plenty of people upset about their case information being online before, but it was so rare that someone actually filed a lawsuit over it. For one thing, what PlainSite does is so obviously legal and above board that no lawyer would take a case challenging the First Amendment right to publish public records. When the guy in Ohio sued, he did it pro se. And when the convicted murderer filed for a counter-restraining order, he did that pro se as well. Plus, it costs money and takes time to file a lawsuit, and filing a frivolous suit risks sanctions, which can cost even more money. So who would be willing to take all of that risk, spend all of that time, and spend the money for the filing fee, the postage, and maybe even the process server? It would take up nearly 2 years of my life, because that orange case transfer notice, the one that I thought contained hints that this might all be a scam, as it turns out, it was. Broken is produced by Think Press and PlainSite, which are both brought to you by Think Computer Corporation. Everything you hear or see on this podcast, the script, the sound design, the mixing, the graphic design, the music, the website, and the DALL-E image prompting, that's my doing. Until next time, I'm Aaron Greenspan.